Hi, welcome to the third installment of our video lecture series. In the previous video, we have discussed the first part of the process in compulsory acquisition, which we've said will start from identification and which will culminate in the cancellation of the existing TCTs and the issuance of new TCTs or transfer certificate of titles to the Republic of the Philippines, who now owns the properties for redistribution later on. But as we've said, even when that acquisition has been culminated, the process in many cases will proceed. The process will still proceed because there may be questions on the matter of just compensation. All right, and just compensation, especially when the landowner declines the initial offer, will have to be determined. Okay, first by the DAR, and then uh, if the landowner still is not satisfied or still does not agree with that, then determination of just compensation by the courts. All right. So first by the DAR. Okay, when the landowner replies to the notice of valuation and acquisition and declines the offer, all right, the Land Bank of the Philippines will have to deposit the amount still, but the matter will be referred to the adjudication branch of the DAR for administrative determination of just compensation. No? When we say the adjudication branch of the DAR, we refer to the quasi-judicial bodies, okay, which will be the ones to facilitate the summary proceedings, which will be the ones to preliminarily determine just compensation in summary proceedings. Note that in this summary proceedings, the conclusion, the result will not be final. No, the determination is not final. As we said, determination of just compensation is strictly judicial, no, because it's judicial prerogative within the framework of our laws. Determination of just compensation is a judicial na prerogative, no, and as we've seen in some cases, especially Association of Small Landowners versus Secretary of DAR, there have been laws, presidential decrees in the past which were declared as unconstitutional for being in violation of this rule, no, for being an encroachment to this judicial prerogative. But as held in Association of Small Landowners versus Secretary of DAR, the allowance of determination of just compensation by RA 6657, no, by I mean granting the power to determine just compensation to the DAR, all right, by RA 6657 is not unconstitutional, not in violation of this judicial prerogative to fix just compensation, because the determination by the DAR is not final unless of course accepted by the parties, in which case there's no more need to call for the judicial to call on the judicial prerogative to fix just compensation. But in case the landowner disagrees with the determination of just compensation through summary proceedings, the landowner is not without recourse. In fact, the landowner can go to the court to invoke the judicial prerogative to fix just compensation, which makes, according to the court in Association of Small Landowners, which makes the determination of the adjudication branch of DAR merely preliminary. Okay, what will hold in the in ultimately what will govern ultimately for just compensation will be the determination of the courts, no, when the this judicial prerogative to fix just compensation is when it is invoked. All right. uh, and so, as we shall discuss later on, when there's this controversy on the matter of just compensation, when there's disagreement with the valuation, with the determination of just compensation, an agrarian dispute will arise, uh, and this agrarian dispute will be properly cognizable by the identified nga mga forums ng mga tribunals, no, which we shall discuss later on in dispute resolution mechanisms under RA 6657. All right. In this summary proceedings, it will be held or conducted by the mga adjudication branch of DAR, but there are mga delineations of what which office within this adjudication branch of DAR has the authority, no, and it's based on the initial valuation. It's based on the initial valuation of the land in question. Okay, because here, no, it's based on initial valuation, right? If the initial valuation is less than 10 million, all right, if it's less than 10 million, it should be the Provincial Agrarian Reform Adjudication Officer, which will be the one to determine, to conduct that summary proceeding to determine just compensation. All right. If it's 10 million to 50 million, it's not anymore the provincial, no, it's not anymore the PARAD, but now the regional agrarian reform adjudicator, or RARAD. All right. And if it's more than 50 million, the initial valuation, it will be the DARAB, or the Department of Agrarian Reform Adjudication Board. Okay. Note that this hierarchy is only for the purpose of distribution of tasks, of course, to to manage the caseloads of these mga adjudication offices, no. In no way should this be construed as a hierarchy for appeal. Okay? It does not mean nga, for example, nagsugod ka sa PARAD, and then if di pagkabong ka mo agree, kailangan ka mo adto sa RARAD, no? And then if you don't agree further, you have to go to DARAB, no? That's not the case here, because this hierarchy is only for the purpose of delineating the functions based on the amount, delineating the roles of these offices based on on the amounts. All right? Because regardless of where you started, whether PARAD or RARAD or DARAB, no, in the administrative determination of just compensation, if you still disagree with the valuation, of course, if you agree with the valuation, then pay na lang si DAR. Okay, mo pay na lang siya. And then, if for example the initial valuation was lower than the second valuation, then mo pay si DAR sa discrepancy. No, very rare cases nga ang notice of valuation, I mean, is higher than the valuation by the adjudication branch. All right, very rare na siya, in which case kailangan na ay refund, right? If i-accept nimo, but of course no landowner will accept a lower amount na noon sa administrative determination of just compensation. So, more likely or most likely, mo disagree gid siya. Mo disagree ang landowner in such a case. Now, if the landowner will disagree even with the administrative determination of just compensation, then as we said, because this is not final, okay, the courts still are granted with the judicial prerogative, no, not deprived sila by RA 6657, then the landowner disagreeing with the valuation, with the determining just compensation, can go to courts immediately. Okay, because under the law, under RA 6657, the courts will have original jurisdiction. Original jurisdiction within the framework of the judiciary na siya. Okay? From administrative determination, which is merely preliminary, the landowner will have to go to the court. Okay? Will have to go to the court because the courts will have original jurisdiction. Okay? In terms of appeals, in terms of grievances against kaning mga evaluation under mga summary proceedings. Okay? Regardless kung nagsugod kag parad, rarad, or even sa DAR, you'll have to go to the court, no? Special Agrarian Court, as we shall discuss in dispute mechanism pohon. Special Agrarian courts are mga regional trial courts which are designated as such. Okay? We will be discussing the rules pertaining to that. Okay? But since here we are in module 4-C, we are still on acquisition. Let's stop there for now, no, sa ato ang process. Okay, and let's discuss the matter of just compensation. Okay, as promised, na mag-discuss ta sa redistribution, no, after maka-acquire na in the next module, and then we will discuss the dispute mechanism, including the procedure for the further procedure when there is a question on just compensation when we reach dispute mechanism. All right. For now, we'll discuss just compensation, because just compensation does not just involve the procedure, does not just involve the rules, but also mga substantive laws, provisions of laws, and jurisprudence on the matter. Very important ang mga principles on just compensation, because these will be the foundation and the guidelines for us to know, no, what would be considered as just compensation, what would be acceptable as just compensation. All right. Now, let's just review the qualification of the court, or the definition of the court in the case of Association of Small Land Owners versus Secretary of DAR. Unsa nang just compensation? What's just compensation according to the court here? Just compensation is the full and fair, the real and substantial equivalent of the property. Okay? It's the full and fair, the real and substantial equivalent of the property. And this equivalent of the property, which is full and fair, real and substantial, not imagined, and not just partial, it is the compensation given to the affected nga landowner. All right? So how do we know if a specific amount is the full and fair, real, substantial equivalent of the property? How do we measure? How do we arrive at the figures, at the conclusion that this amount, these figures, that they correspond to just compensation? Okay, we know that we can. DAR and the courts may ascertain that, of course, by facts. Okay, but these facts alone will not result into uh, the valuation. No? These facts alone will not result into the figures, right? These facts must be based on the factors, okay, under the law. These facts must be based on standards that are enumerated under the law. Okay? Note that, note that we will not be discussing, we will not be enumerating, I will not be expecting you to memorize the kaning factors and standards. They are just in the law, we can just look it up. Okay? But what I want you to remember lang is that under RA 6657, there are several na mga factors, and somehow compared to PD 27, the factors under RA 6657 are more comprehensive, right? As we have discussed in module 3, no? Na PD 27 somehow more simplistic the factors, right? I mean the factors simplistic, while under RA 6657 several, and therefore consequently we can say more comprehensive. All right. Now, bearing that in mind, bearing these facts in mind, now we have a property here. No? This property was a private agricultural land which is primarily devoted to rice and corn, and then na lease tenancy, na share tenancy nag-i-implement, right? This property therefore was covered under PD 27, and so it was subject of the operation land transfer under PD 27. But because of some factors, the acquisition of this land was not completed. No, it was not completed for so many years. In fact, even after June 15, 1988, wala gyapon na complete. No? Meaning, even after RA 6657, wala gihapon na complete. Now, in the implementation, because of RA 6657, no, more intense ang pag-implement sa agrarian reform, this land, which was taken under PD 27, now will have to be completed, no, ang ihang process of acquisition. But in the process of acquisition, since wala pa siya na-complete, there's no payment yet of just compensation. In fact, there's no determination yet of just compensation. Now, in that case, where we have a land which was taken under PD 27, and then the whole process of acquisition of the land was overtaken by the effectivity of RA 6657, a question arises. What law should now govern the factors? What factors should we apply? Should we apply the one under PD 27, or should we apply the ones under RA 6657? This is precisely the question that was answered in the case of Land Bank of the Philippines versus Dumlao in 2008. Okay? According to the court here, the short answer is that it should be the factors under RA 6657 that should govern. Okay? Why? Why? According to the court, for 3 reasons. First reason, the factors under RA 6657 being several and covers more circumstances as compared to PD 27 nga one factor lang and one aspect, one angle lang of valuation. According to the court, if we are to give full and fair and complete nga amount which will be just compensation, okay, we should then apply the factors under RA 6657 instead of PD 27, because applying the factors under RA 6657 will result into a much fuller, much fairer, and much more complete na value, no? And which will be considered as just compensation under the circumstances. All right? But note, okay, this rule, no, applies only to those lands which are covered by PD 27, okay, subject under OLT under PD 27, but whose acquisition was not yet complete even after the effectivity of RA 6657. This does not apply to those lands which were already completed. I mean, to those mga acquisitions nga already completed before RA 6657. Because in that case, kung man na, completed na ang process of acquisition, there's no more need to assess again what's full and fair and complete. Right? Just compensation. But in those cases nga kanina, overtaken ang process of acquisition under PD 27 by the effectivity of RA 6657, according to the court, it should be nga RA 6657 nga factors ang gamiton. Alright? In effect, therefore, in those limited cases nga the land was acquired under PD 27 but not complete, no? It was not completed and even after effectivity of RA 6657, in that limited kaning subject, the rules of RA 6657 will be applied retroactively. Okay? Will be applied retroactively. And according to the court, even though this is a substantive law, which as a general rule cannot be applied retroactively, according to the court, this in this case, no, this law, this particular provision or the factors under RA 6657 may be applied retroactively based on equitable considerations. Equitable considerations because, as we said, the factors under RA 6657 affords the landowner with a fuller, a fairer, and more complete value as just compensation, no? Compared sa katong PD 27 lang nga factor. All right? That's LBP versus Dumlao in 2008. Right? Now, we have these factors. No? What's the significance of these factors under RA 6657? Again, we will not enumerate them. Okay? Just look it up in the law and these factors. Not expecting to memorize these factors even. Okay? What we want to know are the principles that apply to these factors. Especially this, no? The importance, the significance of these factors. More especially, what are the characteristics of these factors? All right. Let's divide the discussion between the administrative determination and judicial determination. All right? Because administrative determination, as we said, no, determination siya by the adjudication branch of the DAR, preliminary in nature siya. Now, when determining just compensation, the adjudication na branch of the DAR must follow, okay, the factors, because the factors are mandatory. Okay, what's the effect if the administrative adjudication or the determination, administrative determination of just compensation is not based on these factors? The valuation, the determination that is not based on those factors will be considered as invalid. All right? Note that the valuation only is invalid. It does not invalidate the whole proceedings. All right. This is the ruling essentially in the case of spouses Lee et al. Versus Land Bank of the Philippines in 2008. Okay? Very important nga kung administrative determination tungod kay mandatory man kaning factors, it's mandatory for the DAR mga adjudication branch to follow these factors, no? And the consequence for not following the factors will be the invalidity of the invalidity of the valuation of the DAR, no? But only the valuation, not the entire proceedings. All right? We distinguish this. We compare this with the significance and importance of the factors for judicial determination. All right? It's important that we try to compare this, try to distinguish, because somehow there's a difference in treatment, because as we know, the fixing of just compensation is a judicial prerogative, and therefore if it's a judicial prerogative, it should not be intruded by the other mga co-equal branches of the government. It should not be intruded by the executive. It should also not be intruded by the Congress, right? So if for example Congress through a law imposes upon the courts factors straight-jacketing therefore the courts in the exercise of this prerogative to fix just compensation, then there may be a problem there, right? There may be a problem or a potential violation of the prerogative. But then, according to the court, it's not really the case here. It's not really the case in RA 6657, because what happens is that when it is now a judicial determination, okay, as a rule, because these are factors laid down by the law, these are mga reasonable nga mga factors, then as a rule, yes, mandatory gihapon because this is a law and courts ought to apply the law. All right? But in order to preserve that judicial prerogative of determination of just compensation, all right, courts, unlike DAR, are allowed to deviate. Courts are allowed to deviate from these factors. Now, because ultimately, prerogative man sa courts, sa judiciary, ang pag-fix of just compensation. Okay? And because they have this prerogative, deviation from the factors under the law, okay, although mandatory siya, deviation from the factors would be allowed. Okay, in the exercise of judicial nga discretion. Okay? Note that in the case of Alfonso versus Land Bank of the Philippines in 2016, the court said that yes, deviation is allowed, but such deviation is allowed only when the court finds that there are grounds to deviate. Meaning, if the deviation is supported by reasoned explanation, grounded on evidence found on record, according to the court in Alfonso versus Land Bank of the Philippines in 2016, deviation is allowed. All right? And also, the offshoot to this is the rule or the ruling in the case of Land Bank of the Philippines versus Honeycomb Farms in 2012, right? Because according to the court here, no, although yes, deviation is allowed, there must be reasons nga mo-support anang deviation. Okay? There must be reasoned explanation nga mo-support ana nga deviation. But no, in case ni deviate si court without such an explanation, without such an acceptable reason, acceptable nga explanation, then what the court will do is tainted by grave abuse of discretion. Tainted with grave abuse of discretion. Okay? If nag-deviate If the court deviates without such reasoned explanation grounded on evidence found on record, then that determination by the court, that determination of just compensation, will be treated by the Supreme Court as tainted with grave abuse of discretion. Okay? And if there's grave abuse of discretion, it will amount to lack or excess of jurisdiction, and we know the effect if there's grave abuse of discretion amounting to lack or excess of jurisdiction, right? The effect is that the determination will be null and void. Alright? Very important to distinguish ang importance sa factors, ang weight sa factors, depending on who exercises the determination. If initial determination, preliminary determination, through summary proceedings, administrative, so we follow the previous rule, okay, nga here, Spouses Lee versus Land Bank of the Philippines, mandatory. If not, meaning mandatory should be followed. If not followed, invalid si valuation, but only valuation, not the whole proceedings. But when the courts are involved na, as a rule, yes, mandatory because courts ought to apply the law, but to preserve that judicial prerogative, deviation may be allowed, but such deviation must be supported by reasoned explanation grounded in evidence. Without such an explanation, the deviation will be considered as an act tainted with grave abuse of discretion amounting to lack or excess of jurisdiction, and therefore the determination by the court will be null and void. Alright? Now, let's consider this factual sequence. No? Here we have RA 6657 taking effect already. Okay? Nag-take effect na siya. And then, while nag-take effect na siya, as of that moment, as of that date, covered na tanan. Covered na tanan ng mga agricultural lands. But then, after that, even if covered ng agricultural lands, the land, this particular land, which was agricultural land, was reclassified to residential. As we know already, after RA 6657 took effect, reclassification alone will not be enough in order for it to be not covered by RA 6657, right? There must be an order of conversion from the DAR, no, coupled with that reclassification. Now, because there's no conversion yet in this set of facts, the land was still covered under RA 6657. In fact, the land was still acquired under RA 6657, notwithstanding the reclassification, because there's no conversion yet. Now, we have a scenario where the land was covered and acquired by RA 6657, but is already now reclassified as residential. No? Residential na siya. So the question is that, will the land be valued as residential land for purposes of just compensation? And it matters, really, because if you're talking about huge tracts of land, a 10 peso per square meter, for example, will result into hundreds of thousands or millions. All right? Because as you know, agricultural lands much lower ang value than, let's say, residential, then industrial, then commercial, right? Let's just say, this is not concrete values, right? Let's just say agricultural lands 10 pesos per square meter, valued at 10 pesos per square meter, but residential lands valued, let's say, 15 pesos at per square meter. So there's this 5 peso discrepancy per square meter, right? Transpose that to hundreds of hectares, that will mean millions, right? So necessarily, under this set of facts, if we try to argue that it's agricultural, then it's much lower. But if someone argues that it's residential in order for him or her to get much higher nga just compensation. Okay, so there's this question, uh, in this scenario, what should be the basis? How should we value the land? Should it be valued as residential because it was reclassified already, or should it be valued still as an agricultural uh, land? This was the question in the case of Land Bank of the Philippines versus Livioco in 2010. Now, in this case, according to the court, essentially according to the court, uh, will value it still as an agricultural land. Okay? Because without an order of conversion, this land is still agriculture. This land is still agricultural. Okay? This land is still agricultural, and therefore it is covered under RA 6657. Right? Now, what about the reclassification? Supreme Court. There's already a reclassification by the local government unit that this land is already a residential land. And should that not bear a weight in the determination of just compensation? According to the court in this case, no, that reclassification as residential land just establishes this land to have the potential use to being used as residential. Right? Potential use na siya. It's not the actual use. And therefore, it should not be the principal criterion for determining just compensation. Okay? According to the court, yes, potential use may be considered as a factor within the provisions of RA 6657, but it's not the ultimate factor in determining just compensation. Yes, there's potential use, especially that in this case, located in a residential area. There's potential use there, okay, and that may be considered for as factor in the determination of just compensation, but that cannot alone be the basis for the determination of just compensation. Okay, the fact that it was reclassified into residential will not warrant the valuation of this land as a residential land, because lagi that reclassification will just involves only the potential use of the property. All right, now let's move on to form of just compensation. As we've said, discuss this in our introduction and in so many video lecture series already. Under RA 6657, just compensation will take many forms or several forms. No? In fact, in the case of association versus of small landowners versus Secretary of DAR, no, question man gani na, as we've discussed in our introduction, no, question ng fact nga just compensation within the provisions of RA 6657 may be paid in terms of other modes other than cash. All right, according to the court, this is a revolutionary kind of expropriation. This entails billions. In fact, the initial na allocation would not be enough. No, initial 50 billion ba to, which was substantial at the time, for the standards at the time, was still not enough. No, the government should be allowed some flexibility or latitude to be able to carry out, no, this grand grand framework, a grand project of agrarian reform. According to the court, gani, it must have been within the intention of the framers of the Constitution to allow the Congress to be flexible in that area, no, to know that agrarian reform would be able to cover huge tracts of lands in the Philippines, and therefore, in order to acquire them, there must be so much resources to be expended, no? And because the government only has so much cash, but it has other mga resources, it's allowed and it's recognized here nga pwede ang other kinds of forms of just compensation. especially when jurisprudence is bereft of any prohibition against mga other forms of just compensation. While traditionally cash payment gid siya, but nowhere in our case books ingon only cash. All right. So in this case of association versus of small landowners versus Secretary of DAR, according to the court, these other forms of just compensation, they are allowed. Okay. So what are these other forms of just compensation? Okay. So cash payment. It's a given, right? But aside from cash payment, just compensation may also come in the form of shares of stocks of mga government owned and controlled corporations and the Land Bank of the Philippines. No, let's just call these mga equity equity instruments, because as you will learn in your international business law, I think uh, there there are two kinds, no, of securities: equity and debt. Okay, equity ni siya because you own something, shares man nimo of stocks, you own something from in those mga government owned and controlled corporations. You owned a part also of the Land Bank of the Philippines when you are issued a shares of stock, or a share of stock. Okay, that's as an equity nga security, equity nga instrument. Okay, also according to the law, RA 6657, uh, allowed pod ang mga debt instruments, no? But here, debt instruments, specifically debt instruments in the form of Land Bank of the Philippines nga bonds, no? You will learn later on sana siyang bonds, but essentially for general knowledge lang, bonds, instruments which are payable at a certain time, no, with interests, of course, na siya value which will be paid by the Land Bank of the Philippines when it matures. Matures meaning when the specified period will come. All right. Basically, that's the general idea. But it's a debt instrument here. You don't own something from LBP, from the Land Bank of the Philippines. It just means that LBP owes something to you, or owes the value of the bonds to you, of course, with the interest. And then equity here, shares of stocks, you own something out from the issuing corporation. All right. And also tax credits. Some of you or many of you have taken tax na siguro by this time. So you already know what tax credits are, diba? These are amounts which are credited against your kanang, not your taxable income but your tax due. Okay? These are recognized according to RA 6657, recognized ni sila ng mga forms of just compensation, all right, as upheld in the case of Association of Small Landowners versus Secretary of DAR, no? Here. Okay? Now, the last part of our discussion would be on retention rights. Okay? Because the matter of acquisition and, of course, payment of just compensation there will affect the ownership of the landowner. And as we know, landowners are also given the opportunity to retain a certain portion of the acquired land. No? Here, in that regard, retention rights are applicable. Okay, which we will discuss kaning retention rights in the next part of our video lecture series. All right, see you there.